Let me explain the basis of our decision today in the case of Peninsula Securities Ltd against Dunnes Stores Bangor Ltd. This appeal arises out of the development of a shopping centre in Londonderry in 1981. The developer, who had owned the site since 1979, was Mr Shortall. He persuaded the well-known Irish retailer Dunnes Stores to set up the principal store at the centre and to be what is called the anchor tenant on a long lease. But in return, Dunnes required Mr Shortall to promise not to permit any major store to be built on the rest of the site in competition with them. His covenant, which is the subject of the proceedings, was not to cause or permit any construction on the rest of the site of a retail unit of 3,000 square feet or more for the sale of groceries or textiles. In 1983, Mr Shortall conveyed the freehold interest in the site to his company Peninsula Securities, which is the respondent to this appeal. Peninsula then became bound by the covenant. On our analysis, nothing turns on this change of ownership. Peninsula wants to be rid of the burden of the covenant. It considers that the centre now needs the addition of another substantial store. In these proceedings, it claims against Dunnes a declaration that the covenant is unenforceable. It puts the legal basis of its claim in the alternative. So far, only the first basis has been considered. Here, Peninsula invokes the ancient common law doctrine against restraint of trade. If the covenant is subject to the doctrine, then, unless the court finds that it is reasonable, it is unenforceable. The Court of Appeal in Northern Ireland upheld Peninsula's claim that the covenant was subject to the doctrine, and so it directed the High Court to determine whether it was reasonable. Today, we unanimously allow Dunnes' appeal against that ruling. We hold that the covenant is not subject to the doctrine and that the High Court should instead turn to consider the alternative basis of Peninsula's claim. The leading authority on the reach of the doctrine against restraint of trade is the decision of our predecessors in the House of Lords in 1967 in the case entitled Esso Petroleum against Harper's Garage Starport. In the present case, the High Court and the Court of Appeal in Northern Ireland sought faithfully to apply that decision, albeit with different results. The majority of the law lords in the Esso case held that a covenant relating to the use of land was subject to the doctrine if the party who entered into it had previously been free to use the land as he wished. Since Mr Shortall had been free to do so, the covenant was, by reference to that test, subject to the doctrine. But over the last 50 years, the test adopted by the majority has been heavily criticised and has been discarded in the courts of Australia and parts of Canada. On close analysis, we find no logical basis for a principle that the doctrine is engaged in the event that the covenantor had been free to use the land as he wished, but not otherwise. In the Esso case, Lord Wilberforce disagreed with the test adopted by the majority. He favoured a conspicuously pragmatic test under which the doctrine was not engaged if the covenant was of a sort which had become generally accepted as appropriate to the type of transaction in which it had been entered into. This court is always extremely cautious about departing from a decision of its predecessors, but we have unanimously resolved to depart from the test laid down by the majority in the Esso case. 4 of us then proceed to adopt and to apply Lord Wilberforce's test. There was evidence before the High Court that it is not uncommon for anchor tenants in shopping centres to extract covenants which restrain the introduction of other large stores onto the site. And the prevalence of such covenants is clearly confirmed in the evidence recorded in 2 Canadian decisions and in 1 Australian decision. The other member of the court upholds Dunn's appeal on a slightly wider basis. It appears that the doctrine, which of course makes inroads upon freedom of contract, has never been applied to a covenant relating to the development of a shopping centre. This leads Lord Carnwath to consider that there is no reason of public policy for extending it to that situation.